Pleasure to be here. I'm Stuart Taylor, and our topic is federal initiatives in K-12 school bullying prevention. I'll spend 2 to 3 minutes sketching the background. Then our 5 expert panelists, whom I will introduce before each of them speaks rather than all en masse, will have up to 7 minutes each for opening statements. Then I'll ask 5 or 10 questions seeking brief answers from the panelists. That should leave ample time for Q&A from the floor. We've had school bullying for as long as we've had schools, of course, but in recent years it's become a highly publicized problem, in part because of technological changes that enable bullies to hound their targets even when they're in the privacy of their homes through Facebook and other media. Education Secretary Arne Duncan said in a speech in March at a White House conference on bullying prevention that over the course of 1 month, 5 young people took their lives after being bullied or harassed for their actual or perceived sexual orientation. Such events have led to a major Obama administration initiatives to involve the federal government, including millions in federal spending. In an October 2010 letter to the heads of all educational institutions receiving federal funds, Ruslan Ali, or Ali, I'm not sure how to pronounce it, head of the Civil Rights Enforcement at the Education Department, told school principals and others that many cases of bullying amount to harassment based on race, disability, or sex, especially of students perceived to be gay. She said that this implicates federal civil rights laws and that schools could face lawsuits or loss of federal funding, she implied that, if they fail to take steps deemed adequate by the government to end such harassment. The letter said that schools would be responsible not only for violent bullying on campus, but also for nonviolent harassment off campus as well, including even teasing, which can be harassment depending on how harsh it is or how you interpret things. It would also include cases of pure speech, such as after-hour postings on Facebook. The letter suggested that remedies could include sensitivity training for all students, their families, and school staff. This initiative has engendered strong criticism on various legal and policy grounds, including the absence of any federal statute explicitly protecting against harassment based on sexual orientation and First Amendment and privacy concerns. Criticisms have come from the School Boards Association and 2 of our speakers. They are Hans Bader, who will go first, and Todd, who will go last. Fatima Goss-Graves, who will go second, and William Yeomans, who will go fourth, have a more favorable view of the Obama initiative. Eugene Volokh, who will go third, will analyze the First Amendment issues in some depth. Hans Bader is senior attorney at the Competitive Enterprise Institute. He previously worked as an attorney at the Center for Individual Rights, where he handled free speech, federalism, and civil rights cases, and at the U.S. Department of Education's Office for Civil Rights. He's a graduate of the University of Virginia and Harvard Law School. Hans?
Obama administration officials call bullying an epidemic and a pandemic, but in reality, bullying and violence have steadily gone down in the nation's schools, as studies funded by the Justice Department have shown. As the Associated Press noted in 2010, there's been a sharp drop in the percentage of America's children being bullied or beaten up by their peers, according to a new national survey by experts. The study, funded by the U.S. Department of Justice, found that the percentage of children who reported being physically bullied over the past year had declined from nearly 22% in 2003 to under 15% in 2008. The myth that bullying has risen among girls was debunked in a 2010 New York Times column, The Myth of Mean Girls. As it noted, this panic is a hoax. We have examined every major index of crime on which the authorities rely. None show a recent increase in girls' violence. In fact, every reliable measure shows that violence by girls has been plummeting for years. If bullying has gone down, how can it be a pandemic? By broadening the definition of bullying to include speech and vague power relationships. The anti-bullying website nobully.com defines even eye-rolling as bullying. So if you roll your eyes at a bully, you yourself can be accused of bullying. Its ridiculously broad definition has been adopted by schools like Fox Hill and Alvarado Elementary, which define eye-rolling and staring as bullying. As a small middle schooler, I rolled my eyes at bullies. The American Psychological Association also defines some eye-rolling as bullying. A recent survey defined bullying to include the use of one's popularity to embarrass another person on purpose. A student can even be deemed guilty of bullying for not inviting a hostile classmate to her birthday party, since social exclusion is considered bullying. 45 states have laws requiring public schools to adopt anti-bullying policies, but there's no federal law against bullying in general. That hasn't stopped the Obama administration from trying to federalize bullying. Its stopbullying.gov website defines teasing as a form of bullying and rude or hurtful text messages as cyberbullying. Since creating websites that make fun of others also is deemed cyberbullying, conservative websites that poke fun at the president are presumably guilty of cyberbullying under this strange definition. School bullying can only violate existing federal law if it involves racial or sexual or disability harassment. Moreover, harassment by students violates federal law only if it's condoned by school officials and is severe and pervasive. In its 1999 decision in Davis versus Monroe County, the Supreme Court ruled that schools can be sued only when they're deliberately indifferent to sexual harassment, of which they have actual knowledge, that is so severe, pervasive, and objectively offensive that it can be said to deprive the victims of access to the educational opportunities provided by the school. As it emphasized, damages are not available for simple acts of teasing and name-calling, nor are they available for even severe one-on-one peer harassment if it occurs just a single time. Thus, federal law does not ban most bullying. To be actionable, harassment must be both severe and pervasive in school, rather than severe or pervasive as in the workplace. This limit on liability may have been a response to Justice Kennedy's dissent, which noted that court rulings had cited the First Amendment to strike down campus harassment codes modeled on workplace harassment laws. Federal civil rights laws do not ban sexual orientation discrimination. By contrast, most schools do prohibit anti-gay harassment. Many states and municipalities do have gay rights laws, and most states have hate crimes laws that cover gays more broadly than federal law. Despite the fact that federal law does not prohibit anti-gay harassment, the Obama administration has told the nation's school officials that they may be liable for bullying, including anti-gay bullying. In an October 2010 letter, the Education Department told the nation's school officials to take steps to reduce bullying in schools, saying that some bullying may trigger responsibilities under federal laws enforced by the department's Office for Civil Rights. Contrary to the Supreme Court's Davis decision, the letter told schools that conduct does not have to involve repeated incidents to be illegal and need not be severe as long as it's pervasive or persistent. The letter falsely suggested that anti-gay harassment is usually discrimination based on sex. It cited as illegal gender-based harassment a case in which a gay high school student was called names. By contrast, court rulings have often dismissed lawsuits over homophobic sexual harassment in cases like Wolf versus Fayetteville and Schroeder versus Hamilton School District. The Education Department's letter was interpreted by some news reports as saying federal law already bans bullying in general and anti-gay harassment. The Department of Education states that federal education anti-discrimination laws provide protection against harassment of gay and lesbian students, wrote the American Constitution Society. The Education Department also took aim at student speech outside of schools, such as graphic statements on the internet. It did so even though the Supreme Court's Davis decision based liability on the fact that the school had custodial power over students at school, and the misconduct occurred during school hours and on school grounds. It did so even though cases like Lum versus University of Missouri rejected lawsuits over off-campus conduct. The anti-bullying panic has enriched high-paid consultants. After New Jersey passed an anti-bullying law, hundreds of schools snapped up a $1,295 package put together by a consulting firm that includes a 100-page manual. Federalizing bullying would harm civil liberties and falsely accuse people. The Education Department has already argued that the existence of a federal law banning sexual harassment overrides traditional protections in school proceedings for students accused of harassment, protections like the clear and convincing evidence standard most colleges once used. It has also argued that students should not be allowed to cross-examine their accusers. It took those positions in a 2011 letter that I criticized as legally unfounded in the Washington Examiner. Under federal pressure, many colleges recently reduced safeguards against false allegations. Banning all teasing is harmful, according to psychologist Datcher Keltner, who says teasing is educational for children and teaches them the wisdom of laughing at ourselves and not taking the self too seriously. Moreover, banning expression like eye-rolling as bullying may violate the First Amendment under the Third Circuit Sachs decision, which invalidated a harassment code that banned isolated instances of hostile speech. Thank you.
Thank you, Hans. Our next speaker is Fatima Goss Graves. Fatima or Fatima? Fatima, excuse me. She is Vice President for Education and Employment at the National Women's Law Center, where she works to promote the rights of women and girls at school and in the workplace. She uses strategies ranging from public education and legislative advocacy to litigation, including briefs in the Supreme Court and federal courts of appeals. Fatima.
Thank you so much. I am very happy that you guys are talking about this topic today. You know, at the National Women's Law Center, we really think that the issues of bullying and violence and harassment in K-12 schools are extremely serious, and we are pleased that both Congress and the federal enforcement agencies and many communities around the country are trying to focus on them now. And they're doing so, we think, because there's a serious impact on both the climate within schools and on the children in those schools. And, you know, there have been a number of reports that have come out that have documented from student perspectives the prevalence of bullying, and one just came out this past week or so from the American Association of University Women. And in their report, they found that nearly half of the students that they surveyed in grades 7 through 12 reported they had experienced sexual harassment in the 2010 school year. And among those, only 9% said that they reported it to anyone. The report also focused on the myriad of ways in which bullying and harassment and violence could seriously disrupt the environment and impact students. The report talked about students saying that they'd experienced sexual harassment and were left feeling self-conscious, embarrassed, afraid, less confident in themselves. Some students avoided school altogether, finding it difficult to study. They reduced their participation in class and in school activities more broadly, and some students, frankly, just stayed home. And I thought it was good that the report touched on the newer technology as well, and it found that a third of students said that they had been affected by cyberbullying in some way, and that harassment had occurred for them either by text or by email or Facebook or some other electronic means. You know, as Hans Bader said, a lot of the reporting recently around bullying has ignored that a lot of local and state governments have been coming up with laws and policies to address bullying, but it also has ignored existing federal law. And in many ways, the Department of Education's 2010 guidance was trying to make that connection. Title IX and the other civil rights laws that the Department of Education enforces prohibits discrimination in schools, including discrimination based on harassment. And the Department of Education has long made clear that a school district may violate Title IX when peer harassment based on sex is so serious that it creates a hostile environment, and that the harassment is either encouraged or tolerated by the school or not adequately addressed or ignored by school employees. And so what sometimes is reported in the media as bullying, in some cases may also constitute harassment that is prohibited by Title IX. And I think that 2010 guidance was an effort to explain that, although there is no federal prohibition against bullying, the same conduct could, in some instances, rise to the level of harassment. And so in many ways, what the department said in 2010 was not new. Dating back to 1994, there was guidance on what constituted racial harassment in schools. And then following the decisions in Gebser and in Davis, the department released additional guidance to remind educational institutions about their obligations to address harassment in schools and what constituted harassment in schools, outlining the same standards that they did again in 2010, and that frankly they reminded educational institutions of in 2007 and 2003. Some of the things that they have said is that harassment can take many forms, that includes verbal acts and nonverbal acts, and that it could include the use of internet technology. They've also made clear that the sex of the harasser and the target of the harassment is not the defining issue. So a harasser and a target can be of opposite sex, or they could be of same sex. And the department also made clear that the harassment doesn't have to be directed at only one individual. What is really the relevant question is whether the environment was hostile. So the guidance that the department outlined tracked not only its prior guidance, but many of the cases that have come along in this time and things that the lower courts have said. So for example, the lower courts have looked at this question about whether the harassment has to be directed at a single individual. And both in the Title VII and Title IX context, they've come out and said, if you are in an environment dealing with sexually charged comments, and they don't have to say, attach your particular name to those sexually charged comments for those comments to rise to a level necessarily that's either severe or pervasive. And so they have said that both in the Title IX context and in the Title VII context. I know we're going to have a lot of time to talk, but I just want to clarify two additional things so that we're all sort of talking on the same page. The Davis decision was the first time the Supreme Court spoke on the question of whether you could get damages on peer harassment. And in that decision, the court made clear that it was tying the standard and its decision to the idea that Title IX has an implied private right of action. And so when you're dealing with that type of situation and it's involving damages, the sort of notice that is required and the standard has to be a particular way. And the court made clear that the Department of Education could devise an administrative enforcement scheme to effectuate the goals of Title IX that went beyond that, and that is what the department has done. It has not done things that are inconsistent with that standard, but they have gone beyond. And then the last thing that I want to say, and I think that it relates to the First Amendment question that I know we're going to have a chance to talk a lot about more, is that I do think that is going to be the key question. That's the question that the Supreme Court hasn't yet addressed, is the overlapping relationship between these longstanding civil rights protection, these new technologies, and First Amendment protections. The lower courts, however, have begun to start to address them in some ways, either in the discipline context, and so hopefully we'll get a chance to talk about that as well. Thanks very much.
Thank you. Fatima, next comes Eugene Volokh, who teaches free speech, criminal law, torts, religious freedom, church-state relations, and 20 or 30 other courses. At UCLA Law School, he has written 3 textbooks, over 60 law review articles, over 80 op-eds, and 500 or 600 other articles, and he founded the Volokh Conspiracy weblog. He's an academic affiliate for the Mayer Brown LLP law firm. Eugene.
Thank you. Thanks very much for having me here. There are a lot of things to be talked about on this topic, including the question of what the role should the federal government have in particular. I'm not going to touch on that. I was asked here to talk about the free speech questions, which apply to individual school decisions as well as federal decisions aimed at pressuring individual schools. So I want to basically lay out the legal rules here and the key issues. First of all, what are the permissible speech restrictions under the First Amendment? First of all, there's speech that's within the First Amendment exceptions, and that's whether it's on or off campus. People can be thrown in jail for this kind of speech. They can also be expelled or suspended or otherwise disciplined by school for this speech. Threats is a good example. Libel is an example. Fighting words, face-to-face epithets likely to cause a fight. So there's not much controversy about that. Likewise, with regard to actual physical violence, it's quite clear that that kind of traditional form of bullying is clearly punishable. No First Amendment right to beat somebody up, or there's no right to wedgie, is another way of putting it. Another possibility, there are, however, several other areas in which the court has said the government has special powers, K through 12 educator. And that's particularly clear as to on-campus speech that either is likely to substantially interfere with schoolwork, is vulgar and offensive because of its particular wording and not because of its viewpoint. First case is the Tinker case. The second case is the Fraser case. That advocates illegal drug use and doesn't comment on any political or social issue. That's the Morse v. Frederick decision. And possibly, this is from Tinker, speech that invades the rights of others. So to the extent that people want to defend some of these bullying and harassment restrictions, they could do that either on the grounds that these kinds of restrictions deal with speech that's likely to substantially interfere with schoolwork, or perhaps on the theory that there is a right to be free from certain kinds of offensive speech. Note, in the Sachs case, that Hans mentioned, then Judge Alito, now Justice Alito, wrote the opinion and said it's not clear what invades the rights of others means. Some courts, as he pointed out, take the view that it simply means rights to be free, for example, from libel and the like, so essentially traditional tort law rights that correspond to First Amendment exceptions. But in any event, he said it's certainly not enough that the speech is merely offensive to some listener. So the rules are vague. The rules are also potentially broad. Let me give you one example of their breadth. Just a couple of days ago, a district court in Northern California rendered a decision that upheld a principal's order to students to remove or turn inside out the T-shirts that wore the American flag. These students wore these shirts to school on the 5th of May. There was some other students who wore Mexican flag T-shirts for Cinco de Mayo celebration. There had been a good deal of racial tension or ethnic tension in the school, and the principal said, "Well, you have to remove these flag shirts because they might substantially interfere with schoolwork by prompting fights," and the court upheld that. I mean, I think it's a very unpleasant situation we're in when you can't wear an American flag to an American school, but as a matter of First Amendment law, the judge was probably correct given the evidence that there was such likelihood of substantial interference with schoolwork. So there is actually a good deal of authority that schools have with regard to restricting speech at school, but not unlimited authority. So for example, speech that is it's offensive for political reasons, speech that expresses perhaps anti-gay views or sexist views or racist views or the like, might be quite protected at least until the point where there's substantial likelihood of outright fights as a result. But what's really important, what this shows us is the importance of looking at what the definition is of bullying or harassment before deciding whether a particular policy is going to be constitutional. I'll give you an example. There's a proposed federal bill that was proposed by Congresswoman Linda Sanchez, which criminalized, mind you, this wasn't just a school policy, criminalized any communication with the intent to coerce, intimidate, harass, or cause substantial emotional distress to a person using electronic means to support severe, repeated, and hostile behavior. That is literally what it says. No limitation, by the way, to students. But even if limited to students, clearly unconstitutional. This means that somebody who posts on a Facebook page something that says, my boyfriend cheated on me and I dumped him and now I want him to suffer the way that he made me suffer. That would be speech that is said with the intent to cause substantial emotional distress. Not severe, mind, just substantial. Using electronic means to support, could be severe, or imagine she says it twice, repeated and hostile. So look, if somebody says we want to ban bullying, my question is, what do you mean by bullying? It's not a term that has a legal definition, and some definitions are certainly way too broad. As to harassment, so Office for Civil Rights' Dear Colleague letter says that speech that creates a hostile environment should be punished, even when it isn't directed at a specific target and doesn't involve repeated incidents. And the letter does try to limit that, I think, by saying that it has to be sufficiently severe, pervasive, or persistent so as to interfere with or limit a student's ability to participate in or benefit from the services, activities, or opportunities offered by a school. If you read that narrowly enough to the point where it in fact actually disrupts a person's education, under the Tinker Standard, may be constitutional. If you read it broadly enough to say that any time somebody is exposed to speech that criticizes the identity group he belongs to, otherwise makes him feel uncomfortable as a result of that, that necessarily by itself interferes with a student's ability to fully benefit from the school, well, then I think that would be unconstitutional. The really troubling questions that are raised these days, though, have to do with off-campus speech. Tinker, which said that students have free speech rights but are limited, talked about speech in the schools. That was the issue there. Frederick v. Morse did not involve strictly in-school speech, but involved speech at a school-sponsored activity. And it talked about schools officials have the right, have authority to prescribe and control conduct in the schools. But these days, a lot of the cases, a lot of the controversies involve out-of-school conduct, insulting YouTube videos, insulting Facebook postings. The Dear Colleague letter specifically refers to that. Potentially also participation in anti-gay, anti-Muslim, anti-illegal alien political events, so long as they then cause some disruption or allegedly some interference with the environment for students in school. And it's true, out-of-school speech has in-school effects. The question is that reason enough to justify a restriction on that speech? When we're talking not just about we are in the school, you follow the school rules. What we're talking about here is 24/7 control, 24/7, 12 control, 24 hours a day, 7 days a week for 12 years over the speech of the students. So let me just close with two things. First, the case for broad speech protection, perhaps even broader than it is now. The government forces children to go to school. For many, this means a government-run school. For many people, private schooling is not an option. This is also the most important, most valuable benefit of the welfare state that most people get. It's not a voluntary surrender of rights in exchange for, say, a government paycheck or government subsidy. It's not like, well, you want the job, you got to deal with the rules. We don't ask, do you want the public education or not? You have to have the education. In practice, for many, that means you have to have the public education. So this is really the government forcing people, not just as a condition of subsidy. What's more, children are soon to be voters. And normalizing government control of speech, the worry goes, and I think it's a serious worry, may subconsciously make such control more acceptable when the students grow up. If they are raised in an environment where certain kinds of topics are seen as off limits, seen as prohibited, seen as constitutionally unprotected, they could say, well, now it's different now that we're adults. But they could just internalize the notion that the government should have this broad authority in order to protect people's feelings. Let me close with a case for narrow speech protection. Justice Thomas, in the Morse v. Frederick case, talked quite eloquently about a very restrictive view of the First Amendment. Nobody else joined him, but this is his view. It's also Justice Black's view in many ways. So in the generation before. So let me just close with it. I'm not sure this is right, but I want to put it out there. Rich parents, you and me, we can send our kids to private schools. And those schools might institute policies that are aimed at minimizing distraction caused by fights and arguments, minimizing distraction caused by kids feeling miserable, minimize threats to kids' happiness, not for the sake of avoiding distraction, but just for keeping their kids happy, teaching kids to be decent adults, teaching kids just as a practical matter how to avoid behavior that can hurt them as adults. We have this option, and my sense is many of us would use it. My sense is many of us would be quite willing to send our kids, in fact, might prefer to send our kids to schools that enforce these kinds of constraints, both in school and out, for the sake of the better education, for the sake of their kids' happiness, for the sake of teaching their kids how to behave better. So the question is, why shouldn't poor and middle-class parents have the same option? To be sure, it's an option that would then be forced on everybody around. And maybe, for example, one argument for school choice is it gives more parents true options. But when you have an environment where there's only really one school that is available to most people in the neighborhood, why shouldn't they be able to set up the same rules that many rich parents are able to take advantage of when they send their kids to school? So with that, I close.
Thanks, Eugene. William Yeomans teaches civil rights legislation and the legislative process at American University's Washington College of Law. From 2006 to 2009, he was Senator Edward Kennedy's chief counsel on the Senate Judiciary Committee. Before that, he spent 26 years at the Justice Department working on and supervising civil rights cases. He's a graduate of Trinity College, Boston University Law School, and Harvard Law School, where he earned an LLM. Bill?
Well, thank you very much. It's a pleasure to be here. I want to thank the Federalist Society for having me. I particularly want to thank Dean Reuter for asking me. Dean and I got to know each other many years ago when I did a brief stint at the American Constitution Society, and I was roughly his counterpart. And we did a number of projects together, and I came to truly respect his intelligence and the seriousness with which he approached issues of legal policy. So he's a tremendous asset to the Federalist Society, and now I hope he won't get fired because I said all those nice things about him. Yeah, for Dean. In thinking about my role here today, I thought that maybe the most constructive thing I could do would be to try to add a little perspective in talking about enforcement. Our topic is, I think, enforcement, and so I thought I would try to zero in on that a little bit. And in doing that, I want to emphasize the distinction between bullying and unlawful harassment. Bullying has no legal meaning. It's a term that is used for policy purposes. And it's quite appropriate, it seems to me, for the Department of Education, for lots of people to launch policy initiatives against bullying. I don't think anybody will defend bullying. We have lots of studies that convey the extreme harm that it can do. But of course it is an age-old problem, and it's one about which the law has a limited amount to say. At the federal level, that limited amount is embodied in a couple of civil rights statutes. In particular, Title IX, which prohibits discrimination on the basis of sex in education, and Title VI, which prohibits discrimination by recipients of federal funding on the basis of race, color, national origin, and also sort of tangentially Title IV of the 1964 Civil Rights Act. But the Department of Education has administrative enforcement authority over Title IX and over Title VI. And I think it's helpful in trying to figure out whether we are faced with this, with a great federal overreach and an intrusion on local school districts, to look at how that enforcement actually happens, and then also to look at how the Department of Justice enforces these laws. So at the Department of Education, there are two avenues by which harassment laws can be applied. One is that the department receives individual complaints from people who think they've been harassed or parents of students who think they've been harassed. And the other is through doing compliance reviews. Complaints, once they're received, are investigated. The investigation usually entails contacting the relevant school authority, contacting the complainant, and then talking to any possible witnesses. Once the facts are pulled together, the department investigators take that to the school authorities if there's a problem. If they decide there's no problem, it's done. If they take it to the school authorities, they say, here are the facts. Let's figure out what we can do about it. And the emphasis is on voluntary compliance. The department strives hard to obtain voluntary compliance. If it doesn't obtain voluntary compliance, then things can be escalated to an administrative hearing, and of course the ultimate remedy is a fund cutoff. That never happens, okay? The second avenue is through compliance reviews. And this is when the Department of Education decides that a school district has a problem and it goes out and investigates. The department doesn't have a lot of resources to conduct compliance reviews. So as far as I can tell, in the last year, with regard to harassment, the department conducted a grand total of 1 compliance review. Lightning struck Yakima, Washington. It's not a serious threat of enforcement. So what happens if the department fails? First of all, almost everything stays in the department. But the department does have the option of referring a matter to the Department of Justice. It hardly ever does that. Referrals are extremely rare. But if it does, the Department of Justice can sue. Now, it's important that a referral is required and that the Department of Education hardly ever does it, because what it means is the Department of Justice's enforcement is limited primarily to intervention in private damage actions or filing amicus briefs. And the number of times that it has done that can be counted probably on the fingers of 1, maybe 2 hands. So it has not traditionally been a vigorous enforcement program. And I think looking at the kinds of cases that the department has undertaken is revealing. They are not pushing the edge of the envelope. The cases are really core violations that I think we would probably all agree deserve some federal intervention. For instance, it was involved in a case in Philadelphia, at a Philadelphia high school, where there was a persistent pattern of harassment of Asian students, which eventually culminated in a day of assaults on Asian students that left a dozen Asian students in the hospital. It was involved in a case in Minnesota where there was a long series of incidents of harassment against Somali Americans, which again culminated in a day of violence involving white students and Somali Americans, and only the Somali Americans were disciplined. It was involved in a case in Mohawk, New York, involving a gay student who, before he came out, was subjected to a course of harassment that included the obvious taunts, the use of all kinds of epithets. His cell phone was stolen, his iPod, his clothes were stolen out of his locker, he was pushed, he was finally pushed down a flight of stairs, severely injured his ankle, returned to school on crutches, was repeatedly tripped in the hallway. The way he brought all of this offense on himself was that he acted in an effeminate manner. He insisted on wearing eyeliner. He didn't dress appropriately. So he didn't conform to gender stereotypes. And that's an situation where the federal government has reached discrimination against gay and lesbian students. It's not because of sexual orientation, it's because they fail to conform to gender stereotypes, which obviously leaves open the suggestion that maybe the law should be changed to prohibit harassment on the basis of sexual orientation. There have obviously been efforts to do that. It would require legislation. One of the objections has been that there's been no showing of an increase in incidents of harassment based on sexual orientation. I think that that's certainly debatable, but regardless, I'm not quite sure why that's relevant. We didn't demand an increase in segregation in 1964 before we passed the Civil Rights Act, or in 1965. I don't think there was any increase in voting discrimination. Society has eventually come around to this notion that singling out people for mistreatment because of sexual orientation is wrong. We've done away with don't ask, don't tell. We've made it a federal crime to hit someone in the head because of their sexual orientation. DOMA is probably on the ropes, and I think it's time to give serious consideration to legislation that would extend explicit protections on the basis of sexual orientation in this context. Just in closing, a couple of practical suggestions. I think that Professor Volokh's First Amendment presentation, of course, is extremely helpful. And the statements he made before the Civil Rights Commission, too, I think were extremely helpful in understanding the limits of the First Amendment. And I think that at one point, and tell me if I'm wrong, but I think he may have made the suggestion that there should be further guidance on the First Amendment and that it should involve examples of concrete situations and how the First Amendment would apply and whether it would permit certain acts and not permit certain acts. I think that's a great idea. I think there should be further guidance. I think obviously this is a very difficult area that depends a great deal on context and we need to understand it better. And I actually have a suggestion for the Department of Education, which is that they commission Professor Volokh and maybe Dean Chemerinsky to sit down and work out a series of principles that we could all agree on. It would sort of be the First Amendment super committee. And if they can work it out, then I think we would all feel very secure in following their guidance. So I hope there's a contract in your future. The final thing I would suggest is with regard to statistics, I think it's always a legitimate concern to be worried about whether we have accurate numbers. And in many of the numbers that we depend on here are produced by advocacy groups. The government does not keep exactly the kinds of statistics that we would like. And I think it would be great to improve the statistics. I will say, though, that even without that improvement, the numbers are pretty impressive in favor of enforcement. But I would certainly favor an effort to collect more statistics and more specific statistics in this area. And there is legislation pending in Congress that would do that, and I think it's a good idea. So thank you very much.
Thank you, Bill. Todd Gaziano was appointed by the House of Representatives to serve as one of 8 part-time commissioners on the U.S. Commission of Civil Rights, which issued its annual report with Todd's dissent this past September on the topic that we're addressing today. In his day job, Todd is a senior fellow in legal studies and director of the Center for Legal and Judicial Studies at the Heritage Foundation. Todd?
Thank you, Stuart, and thank you all. I'm just going to begin with 3 points of, noting 3 points of disagreement, but I won't be able to go into them with 3 of the speakers. With Hans, although I agreed with almost everything he said, I do disagree, and I think I agree with what Bill explained, that Title IX the courts do permit suits against those who have failure to comply with gender stereotypes, and I think that for this reason, there's almost no pure sexual harassment claim, and I think that bullying based on sexual orientation is effectively covered. With regard to Fatima's remark that Davis, the Supreme Court said that its standard for school liability did not necessarily apply to the administrative context. I certainly agree with her on that, but she implied that the OCR's guidelines were only administrative instructions. They are, in my view, illegal because they're not trying to administer the standard, they're trying to change the standard in an illegal way. And finally, with regard to one thing Bill said, if bullying is defined as mere teasing, he said none of us want to support bullying. If bullying is defined as mere teasing, I want my daughter exposed to it. And if bullying, because I want her to learn how to deal with it. If bullying is defined as uninvited flirting, she certainly wants it. She would want to risk the unwelcome flirting for the chance that maybe the flirting is welcome. Anyway, in my rest of my prepared remarks, I want to cover 2 points. One is the data point, and one is on unintended consequences. There is no, the reason the data is important is because it's the Department of Justice and the advocates that use the term pandemic bullying. It was the Justice Department who used that term. It is those who are seeking greater federal involvement who are using it. And my data point is that there is no or are no reliable data. I always get that singular plural wrong. With regard to what Hans says, there are some specific reliable data on things like rape and a few instances of bullying, but there is absolutely no reliable data on what is defined as either broadly bullying or on severe and pervasive conduct that amounts to harassment. What that means is that there's no reliable data that would support greater federal involvement in K-12 bullying. I elaborated on some of these points in my dissent with Commissioner Pete Kirsanow on the Civil Rights Commission, but I'm going to try to touch 3 or 4 really quick points. One of the reasons that the data is so unreliable is that the advocates try to lump social behavior they don't like, such as the unwanted flirting, eye-rolling, acts of exclusion, with serious acts of violence or threats. Now, surveys that mix those kind of conduct are going to get very different response rates. In our commission report, we noted that there were 3 studies, all uncritically cited, that said that sexual harassment was 2%, students reported 11%, and 81%. And of course, the 81% had some very interesting, including the flirting. My fellow Commissioner Gail Harriet, in her dissent, had some interesting responses from the kids who were asked in that survey why they didn't, those who didn't report such sexual harassment that's defined so broadly. Well, one of the girls said, because I liked it. If you define sexual harassment so broadly that it includes desirable conduct, it really is meaningless. Secondly, most of the other reports and studies that attempt to define this have such flawed methodology, including serious self-selection bias, unsupported advocacy group claims, that they are worse than meaningful, they are misleading. The fact of the matter is there is no reliable aggregate data on the subset of school bullying covered by federal law. We asked all the experts, none of them could find them. We asked our staff, none of them could find them. OCR, DOJ, none of them could find them. Consequently, there is no data that would support any greater need. I agree with Bill that if there was some level that was serious that the states weren't addressing, but that'll be my second point, we would want to address it anyway. But I do want to end this data point with a observation about our own commission's examination of OCR voluntary resolution agreements. This is one of the tools that Bill alluded to. With approximately 55 million students enrolled in K-12 schools in any given year, the vast majority of states had at most 1 or 2 schools enter into a voluntary agreement with OCR over a 6-year plus period. And many of those complaints may have been resolved because they were without merit. So, although the commission's study said nothing about whether any of these complaints were meritorious, it does undercut DOJ's and other activists' hyperbole about a pandemic of bullying. Even if all of them were serious, 0, 1, or 2 incidents in a given 6-year period in a given state is not a pandemic. Now, my last point that I want to cover is that even assuming Congress were to grant OCR the power that it's trying to grab, or that is proposed in some of the bills, my position is that it's likely to backfire with regard to, and be counterproductive with regard to preventing bullying. I'd be happy to evaluate later why it's silly to think that there's a reason to preempt the states, the 49 states that have statutes and laws, but the states have other authority to other laws against threats and bullying and violence. So with the remaining time, I want to mention just 4 quick reasons why I think greater federal involvement will backfire. First, increased federal pressure will inevitably increase the number of zero-tolerance responses to alleged harassment with ridiculous results. As my fellow Commissioner Gail Harriet pointed out in her dissenting statement to the Commission report, kids in preschool and kindergarten are already suspended or arrested too often for trying to hug their teachers or kiss their classmates. But things can get worse. Some activists now do purport to define bullying to include unwelcome or uninvited flirting. Well, what about unwelcome date requests? Will 12 through K schools now have to pass new comprehensive speech codes that prohibit unwanted date requests unless a student's Facebook status expressly welcomes the new date invitations? Second, expanded federal authority in investigations of trivial incidents will dilute federal attention to the more serious cases in which a particular school really is indifferent to class-based violence. The troubling racial violence that Bill mentioned and that the commission investigated in Philadelphia High School is a perfect example. Almost every school really does want to address serious bullying. The massive resistance of the 50s and 60s is not an apt analogy here. Nevertheless, the current federal law, properly understood, really does have a critical role as a backstop for those rare instances when a school does ignore or contribute to serious racial violence. The concern that this critical but limited role might get diluted or defined down should not be lightly dismissed. Third, greater federal regulatory involvement to prevent teasing and the like will undercut the accountability local school officials and state legislators have to prevent and address all types and degrees of bullying. The more the federal government acts as savior, no matter how well-meaning that may be, the more attention will be directed to Washington. Since few acts of bullying likely will be resolved at the federal level, the shift in perceived responsibility will have a sadly counterproductive result. Local officials who should have the responsibility can play the blame game, and you know how that goes. Oh, we're complying fully with all the federal mandates, and we don't have enough money from the federal government to solve this pervasive problem. This is hardly a trivial concern, given the many thousands of school officials and the millions of kids involved. Even a slight dilution of local accountability can swamp the increased help that the federal government can offer. And finally, one of the zero-tolerance responses worthy of special note is that anti-bullying indoctrination called for by OCR and many of the activists may violate the freedom of conscience and actually teach intolerance instead of meaningful tolerance of differing opinions. The case law suggests that forced indoctrination and intolerance are already too common in supposedly tolerance-building programs. And I refer you to the Harper decision and our dissent for more information on this. So on one side of the ledger, to sum up, is an absence of any evidence or even a coherent argument that greater federal involvement, or for that matter, greater law even at the state level, will make any difference. On the other side, there is reason to believe that greater federal involvement will backfire, particularly as it undermines local accountability to address these real problems and leads to ridiculous results that increase denials of student freedoms. Thanks.
Thank you, Todd, and that's the last of our opening statements. I'll ask 5 or 10 questions directed at specific panelists, and if others want to weigh in briefly after the particular panelist weighs in, that's fine. And I'll ask the panelists to stay at their seats to expedite this, and I'll stand up here. First question is for Fatima. Secretary Duncan gave this a March 10th speech at the White House conference on this, and he said, and I'm quoting verbatim, "The teasing, the pestering, and the jokes at someone else's expense must be stopped," end quote. And the question is, do we really need the federal government to stop kids from teasing one another and making jokes at one another's expense? Does that raise any free speech or privacy concerns for you?
Well, I guess I have 3 thoughts about that. Is this one? The first is that there's a difference between the Department of Education trying to provide appropriate incentives for local school districts to take steps to address school climate. I think that that's something they're doing in the context of bullying, something that they're interested in the context of discipline outside the civil rights laws. The second thing is that, and I would be surprised if Secretary Duncan was suggesting that mere teasing or occasional teasing would rise to a level of a violation of the civil rights laws. But I know that the department has made clear that when conduct does, they want the federal government involved. And, you know, by the time the federal government gets involved in those types of cases, typically something has gone wrong. I mean, there are the rare compliance reviews where they may happen upon an incident, but by the time you have a complaint, the school typically hasn't taken the appropriate response, and you have students engaging in conduct that isn't good for outcomes for either the school or for the students. And then the last thing, I just want to echo comments made by some of the panelists, that I do think that it would be useful for schools to have the sort of guidance about the overlapping considerations of the First Amendment. And, you know, I think the 2010 guidance talked about, here are some examples of things that rise to the level of harassment. They didn't do the reverse. They didn't say, you know, here is an example where a school has gone too far, and I think that type of guidance would be helpful as well.
Thanks very much. Hans, a two-part question. First, if you'd like to respond quickly to the point on which Todd disagreed with you about harassment based on sexual orientation, if I got that right. And second, should the federal government, as a policy matter or as a legal matter, have any role at all in policing K-12 school bullying or harassment?
Well, is my microphone on? Did you all hear me when I was up there at the podium? I'm not sure I even had my face near the microphone. But the case law on when sexual orientation harassment qualifies as sexual harassment is a real mess under Title VII and Title IX. There are plenty of cases that reject claims based on homophobic sexual harassment and say it's not based on sex, like in the workplace in Symington versus Runyon and Higgins versus New Balance, and in schools in cases like Schroeder versus Hamilton School District, and a recent decision from the 8th Circuit. On the other hand, you have the 9th Circuit essentially equating sexual orientation harassment with sexual harassment, and it even managed to come up with a constitutional-based harassment claim as well. So essentially you have a circuit split. So a lot of circuits weed out most sexual orientation-based harassment claims, and others accept most of them and are consistent with essentially what Todd said. So as a matter of federal law, how broadly you can sue depends on what circuit you're in. So how often you can bring such a claim depends on where you are in the country. For a lot of people, it's kind of academic because most of the workplaces in this country are either covered by a state gay rights law or a municipal gay rights law. And at the school board level, not only do you have many state laws that allow pure harassment claims based on sexual orientation, as in New Jersey, or which treat all sexual harassment claims as actionable even if they're not motivated by sex, as in Massachusetts. But you also have municipal ordinances. You have the fact that most schools prohibit anti-gay harassment pursuant to their policies, including in some of those states that do not have their own gay rights law. So as a practical matter, this is often academic, but the case law is a total mess. I believe that the majority rule is that sexual orientation harassment doesn't qualify as sexual harassment, but there are some courts that essentially equate them, and I believe in that Mohawk case, there's a consent decree, you know, after the federal government intervened, that essentially it banned sexual orientation based harassment based on the theory that essentially that is sexual harassment almost per se. So the case law is all over the map. And what was the second question? Let
me come back to that later, and I will come around again, I hope. A question for Bill. The letter that was sent to all the schools says, among other things, I think as Eugene pointed out, a single incident of off-campus speech not directed at a specific target could amount to harassment. And in the remedies department, the letter says, and I'm quoting, the school may need to provide training or other interventions not only for the perpetrators, but also for the larger school community to ensure that all students, their families, and school staff can recognize harassment if it occurs and know how to respond. And the question is, I can imagine someone might think that's a little bit broad. How does it strike you?
Well, I think that, first of all, the overall issue of off-campus speech is difficult. And it seems to me that it's an area where we have to tread very lightly. It does seem to me that off-campus speech that is carried onto campus in any number of ways could have an effect and could be a problem. But barring that, I think it's difficult to reach. The other issue you raise, I guess, is whether a single incident is enough. And it seems to me that that can be a difficult call, but I think it is possible to imagine a single incident that goes unaddressed and leaves someone in a state of concern, fear, in a hostile environment, could run afoul of the law.
Let me ask a brief follow-up. Let's say there are some students who are involved in a local organization that harshly criticizes gays, or harshly criticizes Muslims, or harshly criticizes fundamentalist Christians. And they attend rallies in which they say, homosexuality is an abomination, Islam is evil, we should deport all Muslims, whatever else. And as a consequence, some other students at school feel that even though these students aren't actually saying this at school, they're coming to school, they're looking at them funny. Perhaps they are, perhaps this is just an inference that we draw when we're around people who we know dislike us. And as a result, they say, we feel there's a hostile environment here because of what these people are saying. Mind you, in this case, I'm hypothesizing repeatedly off campus. Would the school then be required to discipline the students for being involved in these political activities off campus because they create a hostile environment on campus?
Not in my opinion. I mean,
well, why not? If it creates a hostile environment on campus.
Let me explain.
Sure, please.
If all they're doing on campus is looking, I think what you said,
Yeah,
or eye rolling
so.
or whatever, I don't think that that's sufficient on-campus conduct to create a hostile environment. I think that obviously we have to tolerate the ability of people to exercise or express their political views off campus. I think I'm very much in favor of that. It's only when somehow those views are imported onto the campus in a way where they actually play out beyond looks, I think, that they can have an impact that could be actionable.
Well, I appreciate what you're saying, but I don't think the Dear Colleague letter takes that view. The Dear Colleague letter specifically says that off-campus speech could be actionable, and I take its view as, first of all, it could be imported, whatever they said.
And isn't the internet always in the school?
Yeah, it might be accessed from the school, but even in any event, people know what other people are saying off-campus. No?
I'd feel a little more comfortable if you were in charge,
exactly.
not completely comfortable, but a little bit more than the people who are in charge.
Okay. Well.
Yeah.
Okay. Well, I mean,
Bill, you've got the floor.
Yeah, I mean,
For a moment.
I don't work for the Department of Education. I'm not here to defend every word in the letter. But it does seem to me that one way to read it is what I said, where there is a sufficient overlap, where there is conduct that occurs on campus that is connected to off-campus conduct. And it could be that, for instance, accessing things on the internet in plain view and talking about them, whatever, could contribute to a hostile environment. On the other hand, I think, as I said before, I think we have to tread very lightly because I think people are entitled to considerable amount of freedom in their off-campus activities.
Eugene, you said two things that surprised me a little bit. The first was the facts of the American flag case.
Yeah, it's on my blog today.
And the second, I think, unless I heard you wrong, that you thought that the judge had made the right decision.
Yes.
And could you elaborate on all that?
Sure.
Because that sort of sounds like a free speech issue to me.
Sure. So the standard rule off campus is that the government can't act based on what is sometimes called the heckler's veto. If somebody is threatening to act violently in response to somebody's speech, the government has to protect the speaker and punish and deter the threatener, rather than suppressing the speaker for the sake of preventing conflict. There are a few minor exceptions to that. The fighting words doctrine is one such. But as a general matter, that's the rule, and that's especially so if you're talking about speech other than kind of face-to-face personal insults. So if somebody is burning a flag in a public park, the government can say, well, this might lead to violence, therefore that'll be, therefore we can suppress it. It has to protect the speech. But under Tinker, both, I think, under its language and as it has been interpreted by the lower court decisions that I've seen, speech on campus can be restricted precisely because of the fear that it'll cause disruption, including disruption, somebody punching the speaker, and then, of course, the trouble is that doesn't just affect the speaker, but also leads to broader melees. There are several such cases having to do with display of the Confederate flag, where the courts have said, well, there's been a history of racial tension here, and this history is sufficient to justify the school in suppressing the speech because it may lead to violent reaction. And that's exactly what the court said in this case, that there had been evidence in the past that students threatened those who wore the American flag on Cinco de Mayo. There was the fear of violence, in part because there had been ethnic-based violence with regard to other things in the past, and that was sufficient to justify the principle in taking preventative measures. The lines as to how reasonable the expectation ought to be and how likely the violent reaction ought to be are a little bit unclear, but at the very least I think the judge made a defensible decision, perhaps even defensive decision, under Tinker. Of course, one question, which I touched on in the second to last slide, is maybe that means Tinker is wrong. Maybe we're giving too much of opportunity for people to exercise heckler's veto in schools. The interesting thing is, one of the complaints was that, well, the principal didn't try to ban the wearing of the Mexican flag, and he said, well, there were no threats about the wearing of the Mexican flag. So there's this perverse incentive that the heckler's veto creates, which is that if you and others like you threaten people you dislike enough, their speech, not your speech, but their speech can be suppressed. On the other hand, if you're tolerant, then your speech can be suppressed because others are intolerant of you, but the speech you dislike will be preserved precisely because you are tolerant. So that could be a reason to reject Tinker. The downside, of course, is, if I were running a school, my main goal would be to try to make sure that the lessons go on and there aren't fights breaking out, and I wouldn't want to spend a lot of time and effort trying to mop up those fights. So I sympathize with school authorities in some measure here, and I sympathize with the court's sentiment in Tinker. But the consequence of that, quite foreseeably, is precisely decisions like this, where the heckler's veto is given full sway, and those who are willing to threaten people for saying certain things can get their way and have that speech shut down.
It's interesting. Could I comment on that?
Sure.
It's interesting when the courts do and don't allow a heckler's veto to function. For example, in the Doob case, the Second Circuit allowed a professor who was probably anti-Semitic to keep on preaching his rants, even though it created a rising furor. Similarly, when you have a gay student who wants to wear a T-shirt expressing a sexual orientation, the courts aren't going to buy a heckler's veto to justify restricting that speech. And yet, in the case involving someone wearing the American flag, they relied upon this heckler's veto to allow the speech to be suppressed. So there really isn't a consistent application of this heckler's veto notion in interpreting Tinker's disruption prong.
Thank you. Todd, how, if you were invited by the Obama administration to revise the letter they sent out, now it's a 10-page single-space letter, so I'm not expecting a 10-page single-space answer, but how would you have revised it? What are the biggest things you think are wrong with it?
I have a 53-page single-spaced dissent, which covers some of this. The first thing is they need to say they'll follow the standards set forth in the Supreme Court Davis, and of course it's going to be as John Eastman testified before the commission, and some of us were sensible enough to adopt. Administratively, you apply that standard in a different way through compliance reviews, but the Davis decision recognized, for example, that the 14th Amendment, of course, prohibits states from discriminating, and students being mean to each other does not of itself make the schools liable. There has to be three other conditions, as I think Hans mentions. It has to be actual knowledge of the school. That one possibly could be relaxed somewhat, although that's the only one. It's got to be severe, pervasive, and objectively reasonable, and it's got to be based on the recognized classes in the federal law. So one thing that the dear colleague could do is say, we are going to adopt the Davis standard. One of the things they did when it was pointed out the severe departures, where they said, well, we're sort of like the Davis standard because that is a contextual standard and ours is a contextual standard. I think it is laughable to say that any contextual standard we can invent is the same as any other contextual standard of discrimination. So that's one. Number two, I think the letter ought to do more than relegate to a single footnote that the First Amendment may apply. And that's where we agreed with Professor Volokh's suggestion and testimony that there needs to be a lot more respect for the First Amendment, but I would not trust OCR, given the way they've drafted the rest of the letter. Their view of the First Amendment protections is very scary. I also think I'm a little nervous disagreeing with Professor Volokh on whether the flag case was right. I think that a school administrator's overriding duty, whether they want to or not, is to also teach the First Amendment. And so I disagree with the court's resolution of giving deference to the school in that particular situation. The final, probably thought off the top of my head, is that OCR seems to be pushing this. The only way to get absolution, Bill said that the funding is never cut off. Of course the funding is never cut off for a good reason. All states and school districts must cave. They become supplicants of the federal government. That's a shame, but that's the truth. And one of the things that I think they need, well, I lost my point. I'll just say they shouldn't be supplicants of the federal government.
Good.
Can I clarify something I said earlier?
Sure.
I wasn't saying that every jot and tittle of the Davis decision in terms of notice and things like that had to be mimicked by OCR. But I was saying that the definition of discrimination provided in the Davis decision about it having to be severe, pervasive, and objectively offensive does have to be followed, because once the definition of discrimination is not something that the Education Department has the ability to fundamentally alter. And the Supreme Court Sandoval decision illustrates that. In Sandoval, the Supreme Court smacked down the agencies and told them that you can't define disparate impact as actionable discrimination in a lawsuit, and probably also not even before the agency, when the statute itself only prohibits intentional discrimination. So they cannot change that severe, pervasive, and objectively offensive standard, even if they were not bound by certain other facets of the decision that don't define discrimination, like the amount of notice needed. So I just wanted to clarify that.
Okay, thanks. Fatima, in terms of the real world impact of this, I think you and Bill both mentioned how limited the Education Department's resources are to enforce mandates like this. Suppose you're a high school principal who gets this letter, or a school superintendent, and suppose hypothetically that you think there's some stuff in it that you don't really want to do. What's to prevent you from just ignoring it? What can the Education Department do to you if you just ignore it?
Well, I mean, I think if you just ignored guidance from the Office for Civil Rights and there was a complaint, and part of that guidance that you ignored was, I don't know, recognizing what OCR has said is actionable harassment, then that would be evidence that OCR would consider as it was conducting its investigation, for sure. I just want to raise a couple of things that have been said to be sure that we're all talking about the same thing. The OCR letter wasn't suggesting that mere teasing or an errant remark or saying one thing to someone, that would be harassment that was severe, persistent, or pervasive. The examples that they provided in their hypotheticals and the plain language of the letter says otherwise. So I think we should distinguish between steps that maybe schools have taken that have shown up in some discipline cases where they maybe have overreached, and what the OCR letter said. Because I think the OCR letter was pretty careful to go the other way and say mere teasing is not enough.
Thank you.
Well, can I just give one example?
Yeah.
One of the things the OCR letter said, in passing, as if it were obvious, is that spreading sexual rumors could be actionable harassment. And it didn't limit itself to false rumors in the sense of libel or slander. It also made clear that statements off campus would be punishable too. And I should say, it makes perfect sense to me that somebody, say, a teenager, about whose sexual behavior is accurately reported, might be extremely upset as a result of that, quite distraught. I understand that, and actually that's good reason why that we condemn gossip in many respects. Yet I would have thought until now that this was constitutionally protected, that if somebody posted something on her Facebook page saying X stole my boyfriend and is now, or let's say, or why cheated on me, and then other people said, oh, that's horrible, that's shameful, it's disgusting, that would be spreading sexual rumors. That would be something that wouldn't just be an isolated incident. And it seems to me, under the letter, that is something that the school would then have to punish the students for, even though they were perfectly accurately reporting on what was going on in their social circle.
The letter is
Can I
just, sorry, go ahead.
You know, I obviously don't work for the Office for Civil Rights, so I was not involved with that letter, but I think that language, or at least I hope that language was intended to capture and explain that that sex stereotypes can look a lot of different ways. I think we have been focused a lot about how sex stereotypes might manifest itself in what also might look like LGBT discrimination if someone is not being what's perceived as masculine or feminine enough. But sex stereotypes can also manifest itself in ways where young women may be perceived to be overly sexualized. And I can imagine a situation where the language that is used and the harassment that is used, a range of stereotypes and words that I'm probably not going to say right now, but things that are derogatory and related to women's sexuality. I think that was an effort to say that this also is sex stereotyping, that if it meets a particular standard, the severe, persistent, or pervasive standard could rise to the level of actionable harassment.
So just to make clear, if students are just on their email or Facebook pages or whatever else, are accurately reporting on essentially gossip among their classmates, including calling somebody, say, a slut because they think that this person wrongly cheated on somebody or something along those lines, or for that matter has more sexual partners than they think is proper, that would be something, even though it happens on their Facebook pages, happens outside school, although of course people can access Facebook pages in school, that's something that then the school would be required under federal law to punish the speakers for.
Now,
I'm sorry, I just wanted to see if is that your sense?
I think it would depend on, again, is it one time? How does it happen?
No,
what is the
they're talking a lot.
But
Lots of us spend lots of time talking about our friends' love lives. So we like to think a little more politely than the hypothetical.
I think there's a difference between talking about someone's love life and using derogatory names.
Yeah, derogatorily. I don't like the fact that she cheated on me.
Right. So I'm not going to use all the names that are used as overly sexualized women in school, but you can imagine what they are. I mean, there's a recent Fourth Circuit case that looked at, so you're raising two different issues. One is what happens on the internet and Facebook and how does it bleed into the school environment and what steps they can take. And the second one is the actual conduct, whether it was said in person or online, whether it could rise to the level. And I think each example is going to be different, but I think what the Office for Civil Rights was trying to say was you should not assume because it is gossip or rumors around sexual activity that cannot be sex-based discrimination. Depending on the context, it may be.
Now, I'm going to ask one more question of Bill, and then hopefully there will be questions from the audience. Bill, I think you said you weren't here to defend the drafters of this letter, but I'm going to push that a little bit.
Defend.
Well, no, I'm going to ask you to evaluate it in this sense. Eugene, I think, as Eugene's pointed out, there's some very broad language in this letter, which, if read in isolation, would seem to say a single incident of fairly mild, nasty talk on Facebook could trigger a harassment investigation. And as Fatima pointed out, there are lots of examples of what can get you into trouble on the harassment front. There are no examples of what might be protected conduct. There isn't anywhere in this letter, as far as I can say, well, it says, well, be careful not to do X, Y, or Z because that would be a First Amendment problem, or be careful not to, have sensitivity training of everyone in the school and their parents over trivia because that could be a privacy problem. What does the balance struck by this letter tell you about the judgment of the people who put it together, the people running this show?
And when did I stop beating my wife? No, it seems to me, look, this is a letter that comes from an enforcement agency, and they are looking at how to enforce the law. And it seems to me that it's easy to construe the letter in ways that we all think might be inappropriate. I mean, just going back to the reference to the term rumors. I agree that in most instances where it is accurate reporting, that probably would be protected. But a rumor isn't usually associated with accurate reporting. It's an unconfirmed, vague, unsourced statement. So it seems to me that if you read the letter that way, it's about spreading likely falsehoods, in which case I think it's perfectly acceptable.
That's even more dangerous in some respects. So the school must examine every rumor that's flying around at the lunch to determine which, have then a truth squad, and then after the truth squad meets, then punish those that turned out, whether in good faith repeated and believed to be true, to be actually false?
No.
Oh, okay.
Case law.
Again,
Case law.
again, we can speak reason with you.
We're going to talk about truth squads. I mean, that does seem to me to be a little bit unrealistic. And obviously,
then how can it matter whether the rumor is true or false?
The case law.
What matters?
Let him finish, then
what
you can
matters
comment.
is whether there is conduct that is sufficiently severe and pervasive that it creates a hostile environment.
Except for
And
OL.
in that context, you would look at statements that were made, and they could involve rumors. They could involve false rumors that would contribute to the finding of a hostile environment.
Sure. Well, one thing that maybe Hans and I weren't clear in talking about the deviation from, in the Davis Supreme Court case, the Supreme Court said it must use the conjunctive and. It must be severe and pervasive and objectively offensive. The OCR says it could be either severe, so one incidence, or pervasive. So if you keep spreading the same rumor, but it's a really mild one, you use the same joke name, that's fine. Or, and what was their third? It wasn't objectively, they turned it into a subjective. So under OCR, any one of those things, it didn't have to be severe at all. If you repeat a rumor that's kind of mild, a nickname that some kid doesn't like, then you're potentially liable.
But I would think it would be unlikely that would result in affecting the ability of the student to participate in the benefits of the school. If it's a mild rumor.
Todd, you're talking about Davis?
Well, I'm talking about how OCR announced how it's going to, it made up its own standard. And by the way, it changed the third.
I'm reminded in Davis, didn't Justice Kennedy write a dissent saying, severe, pervasive, repeated, none of those lines are going to hold?
Yes, and he was very prophetic in that.
Hans, you had a comment.
A common misperception people have is that if there's vulgar language, that's sexual harassment. But sexual harassment has to be a form of discrimination. Sexual orientation-based harassment that uses vulgar language is basically sexual harassment, almost as a matter of course. In federal court, at least as to the moderate and conservative circuits, some claims based on vulgar language, even if they're severe or pervasive, are weeded out because they're not based on sex. So sexual rumors are not necessarily sexual harassment, even in the workplace under federal law.
Yeah,
Can I just say one last thing?
Say one thing, and then let's go to the floor.
But they can be, and I think it's contextual. So there have been recent cases in the Fourth Circuit and in the 11th Circuit that have looked at what is gender-based harassment and what sort of terms that are also vulgar terms, whether they can also be gender-based terms. And in those cases, in the Fourth and 11th Circuit, they said in those particular instances that they were. So I don't think that there's a categorical rule, as you might suggest.
Good. Now, we have folks standing in line. Please come forward with your questions.
Ilya Shapiro from the Cato Institute. Now, I'm not very familiar with this part of the law, so excuse my ignorance, but it seems to me that the obvious, if obviously imperfect solution is in loco parentis. If somebody, this is such a nebulous area that we can't define what exactly bullying is, then the people that we have to make these, human judgment calls, we would want to be the people closest to the action, the teacher and then the principal and the superintendent, rather than a bureaucrat either in the state or in the federal government. So, I'm wondering how it got this far, because given public schools, which is the ultimate problem here, if we just had more school choice and less government monopoly, that would take care of most of these issues. But given that we have to have public schools and we're left with a second best or third best solution regardless of what we have, what's wrong with in loco parentis that can only be overturned if the principal or teacher or whoever does something that's just obviously unreasonable, or whatever standard you want to write in under common law?
I partly agree with this, and I think there should be a different standard for purposes of the First Amendment between the proprietary judgments of a school official versus a regulatory ban, a nationwide regulatory ban from someone in Washington. For example, in the Supreme Court's decision in Connick versus Myers, they noted that a public employer had broad proprietary power within that particular employer to regulate speech, for example, that wasn't on a matter of public concern. But they also noted in passing that if the government as regulator had passed a law against speech, for example, speech that wasn't on a matter of public concern, the same First Amendment protections would apply to the public employee when punished for his speech as would apply to a man on the street where the government has no proprietary power. So I think that just because school officials have the ability to, say, prohibit the American flag when it's disruptive, doesn't mean that some bureaucrat in Washington should have the power and a regulatory law that applies uniformly across the country to ban speech just because a school official with greater expertise and local autonomy might have the ability to regulate the speech in a gray area case.
Bill, could we get your perspective on that
Just a more
question?
practical answer, I think. I mean, I think everybody involved in this area wants to have decisions made at the local level, the school level, by the people in the school. The only time that the federal government gets involved in any enforcement activity is when something has gone horribly wrong. When there has been deliberate indifference to something that is severe and pervasive and is causing a student serious harm, and the school is not taking care of it. So I think that we're not that far from in a practical way from what you're talking about. The federal government is very much a backstop.
Next question? Oh, sure, Todd, quickly.
Just two quick things. First of all, I don't think, with respect to Bill, that this education department is signaling in its broad Dear Colleague letter that it wants to get involved more and threat more. And one example is the education department's school discipline initiative, announcing that if schools discipline one gender more than the other, it may have to get its disciplinary or one ethnicity or race more. This is a very aggressive education department. The only other exception to, I think Cato believes in the incorporation of the First Amendment against the states, through which clause we'll put off for another day. I do think that local officials, barring if they're public, they need to enforce the First Amendment against viewpoint discrimination, ought to be the ones responsible. But as I said before in my opening remarks, they also need to be held accountable, and that accountability is undermined the more people look to Washington and Education Department.
Next questioner.
Could the panel explain what objectively offensive means? Is there a subjective element to bullying where something might be hostile to me but would not be hostile to someone else?
I think it's intended to contain a reasonable person standard similar to the one that the Supreme Court announced in the leading workplace harassment case, Harris versus Forklift Systems, where the court said that you need to show not just that it was subjectively offensive, but also offensive to a reasonable person. The interesting thing is they don't explicitly talk about subjectively offensive in the Davis school decision, but that's implicit in the fact that it has to actually interfere with your education. And how could it interfere with your education without being subjectively hostile or offensive to you? So I think it just is intended to include a reasonable person test to weed out claims by hypersensitive or idiosyncratic plaintiffs.
Any other panelists want to comment on that?
Just to clarify, OCR eliminated its reliance on it being objectively unreasonable. So subjective hurt feelings are enough in the OCR's Dear Colleague letter.
Next question, please.
Hi, Crystal Lyons. I'd like to post a hypothetical, though not unrealistic, example that I hope will tease out some of the tension between what qualifies as a school-sponsored activity and the increasing use of technology. So if you have a website that's similar to, an amalgam of Facebook or classmates.com, where, say, a high school president can start a class page where members of the class can register and create profiles. They can post calendars of activities, pictures of school events, maybe even sell prom tickets or something. If somebody starts posting bullying messages on that, what's the panelist's view on what the legality of those posts are now, or liability for those posts, and then what do they think it should be?
Eugene, you want to start on that?
So I'm sorry, so you're hypothesizing somebody who sets up a page for current students of the class?
Yeah, a private website, but then, a high school class president can set up this.
I think the first, in the situation you described, probably the first remedy, as a practical matter, would be, I would suppose that the person who set it up would want to delete those messages himself, and would probably be free to do so if he does it in a private capacity. Maybe even if it's done in a school capacity, the school could say this is our speech, even though we invite comments by others, and we can edit that. I think the real concerns that are raised, and query what the First Amendment implications of this are, but the real concerns that are raised are ones where stuff is posted on the webpage of somebody who controls the webpage and likes the stuff that's posted, but other readers might not, others who hear about it might not, or when things are posted directly to the insulted person's page, where even the process of deleting them just sort of reminds them of the insult. But in what you're setting that aside, on top of that, a school could, in principle, under existing law, punish students for certain postings there. And my guess is, given the Morse v. Frederick case, if that's seen as a school-sponsored activity, the school would be seen as having pretty broad authority to discipline students, for example, for vulgar things that they post there or disruptive things that they post there. So under existing First Amendment law, it would probably be treated as kind of on campus and thus subject to a great deal of restraint, rightly or wrongly.
Do you think the school would have an obligation to do so?
Well, under the OCR view, probably yes. And I imagine at some point, even under Davis, probably it would be.
Okay, we've got about 5 minutes, so could we have the next questioner?
I participated with the California Advisory Committee to the U.S. Civil Rights Commission 2 years ago to hold a hearing in California on the chilling of speech in university campuses. The hearing revealed through the discussions that students in freshman orientation are taught that the right to be free from harassment is equal to, so when you're talking about the overlap, is equal to free speech rights. And to Professor Volokh's comment about how this sense pervades the community as students, either discussion of this in the community or students graduate, I have appeared before 3 or 4 city councils and a county board of supervisors over the last few months as they have been called upon by, in this case specifically, Islamist political groups like CARE to issue formal apologies for something that someone said. But the standard that the cities are using, the counties are using, in fact, the county issued a condemnation, used the word condemn, but they're moving very much to a European sense of creating an environment of hate. So this whole idea that students are coming out of the universities with, that an aggrieved party can veto the speech or conduct of someone else or another group, is rapidly taking us toward this European sense of, should this be criminalized, and are we already doing that with these condemnations? What is being done to educate, inform, a la the Westboro Baptist Church case decision, where we've been given in America such a huge space for discussing matters of public concern? What is being done to educate the school officials, the politicians, the people that have this sense that there's already a law against speech that somebody finds offensive? So I know FIRE's doing a great job, but is there anybody that is directly contacting to say maybe there should be a revision of this Dear Colleague letter in a sense that this is another way to look at it?
Anybody have a thought on that?
Are you talking about the April 2011 Dear Colleague letter?
Right, this whole idea that administrators get a letter that says one thing, and it is, with the fact that Tinker standards, or the Davis standard, the OCR may have now supplied the word or, but that there's now a conditioning to look at this as if it's already, and in the minds, at least I can tell you, of city officials, and the bullying coalitions are in these audiences. So when there are these city council meetings, the bullying coalition with the care group show up. And a politician never wants to be on the side of bullying. So the sense of free speech is really getting lost in the pressure that's being put on these officials, and they don't have resources when it comes to constitutional free speech, First Amendment advocates.
Sorry, go ahead.
I was just going to say, I think that a lot of people on this panel would agree that two different types of guidance are probably needed, one related to the First Amendment. I also think that there needs to be guidance related to discipline as well, because of the interaction between a harassment or a grievance procedure and a disciplinary process. I think that there are a lot of there's probably a lot of confusion at the local level, and that would be useful. But in terms of revising either the 2010 bullying and harassment guidance, or I wasn't sure if you were also talking about the 2011 guidance on sexual violence, which I know FIRE has been really critical of. I would say I would disagree that those guidance either said things that were very new and different. They largely just reiterated policies that had been long-standing, or B, that they have led to more confusion. I think in many ways they provided additional clarity.
We've got 30 seconds and one more questioner, so why doesn't he ask his question and you give a short answer?
Well, first of all, thank you for the previous comment. My name is Andrew Kloster. I'm a legal fellow with the Foundation for Individual Rights in Education. First, a very brief comment, which is sort of glib. If I were Todd answering how would I fix the OCR letter, I would say, first of all, I would comply with the APA. I would try to follow administrative law when issuing things via notice and comment rulemaking. But my actual question is none of you talked about the incorporation of acceptable use policies on school computers, and how many of these things could possibly be bullying. If a school prohibits bullying on the computer, it's possible that a prosecutor on the other end of the country picks these things up and prosecutes a student criminally. So I was wondering if any of you could comment on that.
I've just been told that the room needs to be given to someone else, and that the answers to that question could be given privately if you want to come on up. And if anyone who else wants to see them, come on up. Yeah. Thank you to all of you.